uh, with people online, offline, and many times Professor Surya, Professor and young friends. I have typically made it a habit to address not those in the front row. So pardon me, those in the front row. My attention is on all of you at the back row. The very back. Yes, that means you whose face is hidden with yes, including the other lady there, the back. Yes. So that's where my attention is. So when Professor Subramania said there's this seminar, I've had occasion to come here a few times, but there has been an elephant in our room that everybody is blind. And so I said, let me draw some attention to this animal that has entered our minds. Can you imagine a medical college which does not contemplate the idea of death, that does not confront death? Would that medical education be complete? How can one study health without understanding the process in which health is depleted? Now, death is an inconvenient topic. Any time of day or any time in life you raise it, it sends a feeling of discomfort. Yes, the nature of the topic is that. But does that mean you avoid it? Does that mean that you do not accept the ephemeral nature of all our existence? It has to be confronted. In the idea of the creation and implementation of international law, there are some axiomatic assumptions. That is to say, the assumption that nation states exist, will continue to exist. We don't know. As long as they do exist, yes, okay. Then they're entitled to create some form of rules that they must interact with each other. But even when they create those rules, exceptions get created. And then you are seeing that the exceptions might be so abundant that one has to look for the rule in the first place. Now, contemplate what am I referring to. In an age of multiple wars, both seen and unseen, imagine if we are all under cyber arrest, cyber attacks, cyber war, all unseen, biological war, this, that, God knows what else, ecological war. On top of all, there's a physical military conflict. This is the time we're living in. Now, on top of this, you have a new weapon system that states have given to themselves. The animal I'm referring to is sanctions. So far, that has felt like somebody else's problem, not our problem. Something that happens to people in Syria, Iran, Cuba. So why should we be bothered? Even now, after the United States has last week sanctioned several Indian companies and a few Indian individuals, even today, do you see the word sanctions in legal curriculum? The entire nation is underestimating the relevance and impact of sanctions. Sanctions have the power to impact behavior, Fundamentally, unlike other transnational instruments which are created domestically, that is domestic law that has transnational application, such as corruption. In relation to corruption, you have the Foreign Corrupt Practices Prevention Act of the United States. UK has the Anti-Bribery Act. Australia has a similar such enactment, that is regulating corruption not within the borders of those countries, but regulating the conduct of enterprises and individuals who belong to those countries while they behave themselves outside of those countries. So US companies can fall foul of FCPA if they indulge in corruption in India, in Pakistan, in any other country. In addition to falling foul of domestic laws in this part of the world, they will be falling foul of US law. US law that has extraterritorial application. Yet, it can be said in some crude form that you can trace the notion of FCPA to something as primitive as the Ten Commandments. Something even the Hammurabi Code, who will say do not steal. Where on earth can you derive the moral sanction for the idea of sanction? Unlike corruption, where you're so told there is proper conduct as per your domestic law, do not seek for legalities for a fee. Do not try to exclude from economic activities people on an irrational basis merely on the question of either proximity to political power or because of money power. Those are not sensible prescriptions for every society, isn't it? No society, whichever it may be, based on whichever religion, whichever ideology, if it has whichever economic model, if it has to be resilient, it has to ultimately follow, even if it is run initially by thugs, it will ultimately still have to make sure that the loot is the looting instinct is independent and separate from the functioning of political entity. Now consider sanctions. What is one of the risk? Is it telling you not to covet your neighbor's wife, not to steal, not to murder? What fundamental root that this is addressing? Or is it amplifying? Is it amplifying a real politic instinct to say, I will and I can sanction and I will retain that right because I can. So in a way, it is a demonstration of power. Even today, when you have multiple conflicts, you hear sanctions, you hear typically of US sanctions. You hear typically of EU sanctions. You might hear of UK sanctions. You may even hear of Singapore sanctions. But there are counter sanctions. There are sanctions from Russia, there are sanctions from China. And if you consider all the clothes you're wearing, all the screens, the gadgets that you're staring at, all the goods that you're including the bottle of water, and consider where on earth and this implements in this room, how many countries have created products and services for us to experience this moment here and now. It would cover the majority of countries in the world. So being transnational is an existential fact for us today. It is not a theoretical construct. Components that were on in mind. It's not purely within our borders of India. My spectacles are from some other part. Look at you see so much. Imagine now if each country that has created this moment in an alternate universe, in a multiverse, another universe, parallel universe, have sanctioned each other. Can they trade? Can there be a supply chain at all that is created across borders? So, if you were to then see impossibility, the practical impossibility of total unilateral sanctions by one country on every other country, or on every country on every other country. Such a situation is impractical, unenforceable, illogical. Even if it happens, it will be very short-lived, because the idiocy of that idea will be realized by all. So now we then realize that this is a idea that can be put to use only by a few countries whose trade and say matters transnationally. So those countries with a disproportionate impact on transnational investment or capital flows or transnational trade flows, such countries, when they start thinking and considering of sanctions, and then may consider what that power is. In recent times, and there are earlier times when the notion of sanctions have been considered. And there are distinctions drawn between diplomatic sanctions, economic sanctions, military sanction, environmental sanction, and they may take different forms. Some might say that there is a sanction not to allow certain nationals or come to a particular nation to interact with your nation. For example, there is a body of law, called investment screening law. Investment protection law, you are more familiar with. That is the bilateral investment treaties like ICSID, which protect investment from one country to another after the investment has been made. Investment screening addresses the situation before the investment was made. So, in a way, the entire body of investment screening is an opportunity for a state to consider whether you want to take investment from a particular place or not. Once you take it, you have to protect it. So, in a way, you can have preventive approach to investment, and in a way, a form of sanction by saying that you do not want investment from XYZ countries in, let's say, critical sectors of your economy. It is, in a sense, a form of sanction. It doesn't sound familiar to what India has done. You do not see that as a form of sanction. It's not called so, but I would say it's a species of, let's say, instinct. Right? And now you have find with one statistic that I am just now. I'll come back to it when I do. In recent times, the most visible use and impact of sanctions has been the sanctions imposed by the United States. So let's consider them for a moment. And Professor Subramanian, he suggested that I look at it from a trade law perspective. I said, in addition to that, I talked about investment law also. But the two are intrinsically linked. They are inseparably linked. Now, in fact, investment agreements are not being entered into on a standalone basis. They are being entered into as a chapter as part of a comprehensive economic cooperation agreement, where in the effort to have comprehensive agreement of trade, investment also can be seen. I will now jump to a totally different area, which is the legality of sanctions in broad terms. There are many ways of looking at it. First, an obvious question is, one of jurisdiction. Who are you? Who are you to tell me what to do? Have I voted for you? What relationship do I have as an Indian citizen to the government in the United States? I was not asked who to elect. The plan was not made to me. Why is Trump or Harris coming? They say the US was in labor. We don't know whether it's a boy or a girl. Now we know it's a boy. But so what? Or what jurisdiction would they have over me? Right? So first analysis is of jurisdiction. And here, in 1927, you had a case that went up to the Permanent Court of International Justice. That was called the Lotus case. And the Lotus case dealt with the state's prescriptive jurisdiction extraterritorial. They say that far from laying down a general prohibition to the effect that states may not extend the application of their laws or the jurisdiction of their courts to persons, property, and acts outside their territory, it leaves them in this respect a wide measure of discretion, which is only limited in certain cases by prohibited rules. As regards other cases, every state remains free to adopt the principles which it regards best and most suitable. Some states can say, I want to rule the world from my parliament. Other states can say, no, I want to only pass domestic legislation which has zero extraterritorial application. This 27th principle was that it is your act of sovereignty to determine what type of legislation you want to have. Nobody asked you to have limit yourself. And nobody asked you to be universalist in your thinking. But it is left to the states. But later point in time, this broad approach has come to be tested. And in particular, the positivist understanding of state sovereignty being positively constrained by international. Today, the rules of jurisdiction, if you want to look at this in more detail, there's a 2014 article in the British Yearbook of International Law by A. Mills. And that I'll be referring to. The Lotus case was a case between France and Turkey. That is also 1927. But now, if you look at the rules today, it is on jurisdiction. It is seen to define the limits of powers of coexisting sovereigns. And international law being developed for purpose and rules for states' jurisdiction to be proscribed and prescribed. Proscribed is to prohibit, right? So there are limitations that are thought to be there. In the permissive principle, states need to justify their exercise of extraterritorial jurisdiction based on a genuine link between the regulated subject matter and one of the accepted heads of jurisdiction that they have ordinarily. What does that mean? They have to be able to demonstrate it. Okay. And so, for example, territoriality is easily understood. Nationality is easily understood. But now, nationality does not always coincide with territoriality. What is Mr. Putin saying about Ukraine? There are some nations which may exist in multiple countries. There's a sense of nationhood, but they're not fully formed as a sovereign state. But they consider themselves and they have other attributes of their nation. So these principles may not be aligned. Absolutely. Look at the borders of Africa. Right? They're all drawn up in one conference in Berlin, sitting with straight lines, cutting through people, communities, families, with no logic, with no concern to how local communities have created themselves. Right? So, unlike those principles, therefore, extraterritorial legislation, they need to be able to demonstrate jurisdiction over the action that is contemplated. And for sanctions, the real deterrent is to turn them into enforcement mechanisms for the extraterritorial application of their domestic law. Now, one type of sanction is to it's called access restriction. Like I told you, one is investment screening. Another form is now they're already coming. So one is not legitimate in the first place. That is called investment screening. Next, they're coming. But now you want to limit who can come in tomorrow. Although some have already come from a country that you do not wish to interact with tomorrow. There you say you want to limit access to your market. So they're able to justify some of their activities by saying, we will not allow you to open US bank accounts. You cannot force me to open a bank account for you. So I'm not having extraterritorial application only. I'm only telling my banks, don't open accounts from XYZ countries. So, and I'm acting therefore, my real target and person regularity is my own bank. So, you want to be impacted, yes, because you are coming from a sanctioned country. But the measure that I'm taking is addressed to my own entity, that is US bank. Second, they may say denial of US visa. Well, how can you compel me to give you a visa? I might say no. And my visa policy, I say, do not give visas to persons from certain countries. Or they fall under in ways in which they're able to say these are not even extraterritorial in the first place. Though it's called sanctions, and you might think it is extraterritorial, it impacts those who are not my nationals, but the measures themselves are not extraterritorial in their activity. So that's one way in which states seek to defend the legality of sanctions, certain type of sanctions, by saying that these are restrictive sanctions. When there are other measures that are taken beyond access restriction, then they need to have further explanation. Contrasting the position with the US, the EU has taken quite a different approach. The EU has said that it will, as a matter of principle, they say that, or at least they have said so far, it may change now, is opposed to the principle of extraterritorial application of third country legislation, imposing restrictive measures which purpose to regulate the activities of natural legal persons under the jurisdiction of member states of the European Union. So the EU blocking regulation, for example, is designed, they say, to protect against effects of extraterritorial application of legislation adopted by a third country and action based thereon. So let us say the US sanctions the EU. All right. It's easy to contemplate Iran, even India, whatever. But imagine another multiverse, where in that scenario, US has sanctioned EU. There, the EU is saying that, look, we are not going to respect such a entity, such a measure against us as EU. And they're saying that they would acknowledge, but it's a third-party external application, such instruments, by the very existence, they violate international law. So EU will not say this if it is impacting the non-EU person. We'll say this if it impacts them. But the fundamental position is that we oppose this, because if they accept it, that means they're accepting a scenario one day when the US can, in fact, sanction EU. How do you prevent that? Is by creating a norm that such extraterritorial application or even a restrictive legislation would. And will be today, I would want to view that as a violation of international. So the message will be saying, who's going to sanction EU? Only the US or some other such entity. Okay. But that is a necessary say. But for sanctions beyond access restrictions, there they need to have a further level of justification. For example, there is the Iranian transactions and sanctions regulations, which regulates the conduct of foreign companies controlled by US persons. Foreign companies, so not even US companies, but if they're controlled by a US person, then they get impacted. So, it will come in Dubai, which is set up by Iranian capital. It has a US person who's controlling it. It gets covered by that. Then, as well as re-exportation of goods, technologies and services exported from the US, which can be based on other heads of jurisdictions. But then there are, so you can see how the shadow is growing. Right? You have the umbra and the penumbra, right? In physics, to define parts of the shadow. So very black, easy to identify. There's the shades of gray. So there's one next shade of gray. The next one beyond that is perhaps companies which states attribute nationality and and then where you have measures which are dealing with companies that are in the supply chains of persons facing primary sanctions. So these can be called tertiary sanctions. So once they're removed, so somebody who's selling paint to the veneer manufacturer I described, who had to paint in red and orange, say danger, don't use this equipment, that paint seller, let us say. Now, this is not a factual example because it's being recorded. So now I have to be careful with what I'm saying. So now I'm going to go to defense. Then I cannot be accused of doing some manipulation, impacting one real. So there you have examples in relation to Cuba. There's something called the Helms-Burton Act that talks to the effects doctrine. And there they say that if there are goods, once they have moved out of US territory, normally you will say that good uses US characteristics, right? So once a good leaves, let us say, a shore of a country, can you call it good, let us say, the title is passed, let us say, from a US seller, it is still be exported to the US. In those acts, they have said they will still consider the effect to be the sanctions effect to be continuing on such goods, even if it is passed to non-US entities. So you will see the creeping expansion of the scope of sanctions, right? From original immediate application, restriction, then primary, third, secondary, tertiary sanctions. So, what are the measures by which they can defend themselves if challenged? Now, who is going to challenge United States? I don't know. Find me that David who is ready to fight Goliath. Then that person will need this advice, right? Which is to say, what about exceptions? The most obvious infraction appears to be of which principle? In trade law. Today, all day you've heard trade law. You've heard TLAs. What is a TLA? Three-letter acronym, TLA. So trade law is full of TLAs. Three-letter acronyms. Some of them are two letters also. I'm going to give you a hint. Right? Which are the principles? Attribute treatment. And which is the other one? You can hear it a little bit most favored nation. So, does sanction not violate most favored nation? If I have an obligation to treat all foreign countries the same way and give FFN status to everybody, but I tomorrow say, out of the 200 countries, one country, I don't like your face anymore. Am I still practicing what I signed up for as an obligation of treating everybody the same? So, am I facing violating most favored nation? Will be the first and obvious line of attack. MFN is a duty not only under instruments under trade law, but also under investment treaty law. Will there be such a challenge? I don't know. But there can, is my only point. All right. Second, there can be exceptions to MFN, national treatment, and states may have to say, I fall under this exception. One obvious exception that comes to mind is like even for murder. Give me an example for justification of homicide. What would you say in domestic criminal law?
Self-defense.
Self-defense. Right. So what is the equivalent here under investment treaty law? You can say it's an essential security measure. These guys are out to destroy me. How do you say I can't prevent the attack? So I have to be able to prevent. So it is an essential security measure I'm taking, but then that is again going to be a matter of proof. What is the information? Is it going to be another WMD? Do you know what WMD is? No, it's another TLA, not familiar with. It was the three letters that justified the war on Iraq and war on Saddam Hussein. Talk about weapons of mass destruction. Ultimately, never found. Ultimately, the Attorney General of the United Kingdom withdrew his legal opinion. He gave an opinion saying that the war against Iraq is legal because he presumed the existence, the factual existence of a weapon of mass destruction. When it was found that that factual assumption was wrong, he issued a second opinion telling Tony Blair that this war is illegal. The Attorney General wrote the letter. Of course, he resigned. So, security exceptions are the other option, right? The countries. These are also possible under both trade law and under investment. They may say that this is for sanctions and counter sanctions. You will now have a case where they will say states will assert that it is a retortion or a way of response. So, to one sanction, I will stop by counter sanction. In crude terms, look at the UCOS award. UCOS award was $50 billion. Russia says that this is an indirect expropriation of Russian assets. You wanted to pocket Russian assets, you could not do it directly. Instead, you created this arbitral award. You talk about New York Convention, you want to enforce it against Russian assets, and then you're pocketing this. So, taking a leaf from that approach, that Russia, I'm not saying Russia is right, I'm just saying it's the Russia value. Now, it is now come up with a claim against which company? Russia. Russia has come a claim against which American company? Beginning with a G. Yes, against Google. Before Google became Google.com, when all of us were in school, Google was a number, was an arithmetical number. Now Google is known as Google.com. But the claim that Russia has made against Google, now somebody, yes, you sir, got that. What is the amount you can Google it and tell me? Is it more than a Google or less than a Google? Less than. No, what is, just tell me the exact figure. It is a mouthful. It's about 2 decillions. 2 decillions is the figure. Such money doesn't exist. We paid that. Right? But then there is this claim. Now there is this slavery related claims that countries want to have against England. So all right, everybody is putting a gun against the other side. You say, you owe me, you owe me, you owe me, you owe me, you owe me. But who's got the money? Where's the money? So this cannot be lapsing into luster that is uncoordinated for too long. It's a pack of cards that might collapse, but it will have to be rebuilt. And each generation has an obligation, the opportunity, curse, whatever you call it, to create their own peace, including you. You are not exempt. You cannot say Einstein did work, Gandhi did work, so I'm free. No. You got to do it for yourself. So one such attempt, and I'll stop at this, is the Articles of Responsibility of States for Internationally Wrongful Acts. So that you're able to say that there are some acts that states will come and agree will be internationally wrongful. What are they? How are you going to get states to agree? That's another matter. But for example, if there is coercion of a state to extraterritorial sanctions, that might follow Article 18 of this instrument, ARISWA. Correct? And this similarly, if there is one that is equated with force majeure, then it might be invoking Article 23 of ARISWA. And this is one such attempt. Like this, there will have to be more, where this animal that is now being under strain, which is roaming freely across one entity to another. So in we say the other entity, monster, that political theorists talk about. You studied Hobbes, Locke, and Rousseau. You've heard about the Leviathan. You heard of the Leviathan? So my parting shot to you is, are sanctions a contemporary leviathan that requires restraint? Namaskaram. Thank you.